All right. Got this video from Mr. Freeman. Mr. Freeman is being silly. He said first that he didn't have the prosecution didn't show up today. Today's the 14th. You'll notice there was a hearing on the 7th. It was reset in advance to 8/16. So the next court date was 8/16. Today's the 14th. I don't know what he's on. I've known it's been 8/16 for quite some time. I was concerned because his next Arizona hearing date is the 17th, and I was hoping he was aware of the 18th. Apparently he is now. I do somewhat wonder if he actually did go to court, because normally when he goes to court he's wearing the white shirt and the black tie, and I don't see him wearing that today. He also said that something has changed with regards to Bao. Nothing's changed. It's been like this for quite some time. He's had the bond set at $5,000. It's been for harassment. Amazingly enough, Mr. Freeman just learned that there's contempt. He's been not denying it, but he hasn't been acknowledging it for quite some time. Apparently, with the release of the work that the humble merchant has been doing with Bao, he couldn't tap dance around the whole contempt conviction. You won't see contempt as a charge because he wasn't charged with contempt. He did an act that was considered to be contempt. He had the recording device in court with him. The judge was aware of it. The judge held him in contempt, and then just like when Freeman, he went in with the recording device. PV said, "You're in contempt." The bailiff escorted him out of the room, held him until the cops came, and James Freeman was very surprised to find out that that's all it takes, is for the judge to say, "You're in contempt." That's all that was required for Mr. Bao as well. And yeah, I did check there. The last pass slip was the 7/24. This is the 7/24 one. The reset date was 8/7. 8/7 was reset in advance. 8/7 was the one that his judge was sick for, and so they reset it in advance. And yeah, so he is playing fast and loose. Anyway, little birdies gave me stuff to play with, so we're gonna go over it if my dog doesn't make too much noise breathing into the mic. I am told that the humble merchant kopcam, who is as bad at filling out federal paperwork as he is at selling cheap cameras, he apparently helped Bao with this, and he did a suitably terrible job. You can see this was filed in federal court. So everything in here, even if it's not stamped for federal court, was filed in federal court. See how this is filed in Tarrant County, Texas? Apparently they included this for whatever reason with the federal filing. I don't know exactly why. So Bao, he says he's being held on orders by state authorities and other. He's not. He's being held by the judge. The judge is in a court that is either constitutional or legislative, mandated by the state of Texas. It's a state authority. So I don't know why he did that. He's currently a pretrial detainee and other. He's being held in contempt. It was for in the presence of the judge. He just doesn't understand it. Pretrial detention, check. The validity of your conviction or sentence as imposed, check. Disciplinary proceedings, check. And other, check. These are the what are you challenging in this petition. He never really shows up on the disciplinary proceedings till the end, but the pretrial detention he's challenging and other. So he says he can't have copies of discovery. I don't know if that's true. I will assume that he has not been given copies of his discovery, just arguendo. They may have been given to his attorney prior to him firing his attorney, or the prosecution may not be required to turn them over yet, or the prosecution may not have evidence to turn over, or the prosecution may have turned over all of the evidence the prosecution has. If all the prosecution has is witness testimony, then they'll give him a list of witnesses, and he may not think that that's all the discovery, but it might be. He says contempt of court charges again given while he was in jail. After a second bond was posted, no court in session. Again, he's just not understanding. The contempt was given in the presence of the judge, and then he found out about it later. Just like James Freeman's contempt was given in the presence of the judge, and then James found out what it meant, 10, 15 minutes later when the cops came and arrested him for it to take him to jail. So they have the name of the court, etc., contempt of court harassment. He didn't appeal it. He says he didn't appeal it because he couldn't file any motions. The guards refused to let him give them or submit any paperwork. You mail it in, typically. Typically, motions are mailed from jails. It would beg the question of why he was able to file this petition for writ of habeas corpus if he couldn't get other motions filed. And as we'll see, that was filed on the 10th. That was filed on the 10th. That was filed on the 10th. So he got other motions out. So I don't know exactly what he's trying to claim. Let's see. And then he says that he couldn't do any other appeals because of it. This is what he's trying to do. This is a 2241. He's saying he's in custody in violation of the Constitution or laws or treaties of the United States. That's the only one that works on this federal writ. Now we've moved on to a 28 U.S.C. 2255. This is a particular one. You have to be a prisoner in custody under a sentence of a court established by an act of Congress. He has to be a prisoner in custody under a sentence of a federal court. And he's not. He's a prisoner in custody under sentence of a state court. So this doesn't apply, so he shouldn't have filled any of it out, so I'm just going to skip past it. Other appeals, yes. Habeas corpus, Tarrant County Criminal Court 6. He filed at 7-11. It was ignored. Now, he does go into it up here. The hearing was the 17th of July. You may remember that. That was the hearing that Freeman made a video on. He since deleted it, where he was just exuberant over how comedic Bao was and how Bao really made that judge look bad at asking all of his clarifying questions a la Common Joe. Guess what, kids? It didn't work out the way they hoped. You can't do that. You just can't. So that was this part. Grounds for his challenge in the petition: unlawfully restrained of his liberty in Tarrant County Jail over 30 days of solitary with no sunlight or exercise, no reason stated. That could be a violation of his rights. I think you're required to have an hour of exercise in the yard at a minimum. Maybe that is a violation. He'd have to prove it. So there you go. He says he has video and inmate log evidence. I would be surprised. I mean, it could happen. It could happen. But they wouldn't give him a writ on this one. This would be something you'd want to sue, like a 1983. This would be a 1983 lawsuit. You'd say that, your whatever, your Eighth Amendment is being violated. It's cruel and unusual punishment to not give you an hour of exercise and or sunlight, etc. So this wouldn't be a writ of habeas corpus. This would be a 1983 suit. Ground 2 is unlawfully held on contempt of court charge. Again, he doesn't understand what happened there. if it was an indirect contempt, if it happened outside of the presence of the judge, then there would have to be the whole due process thing. They'd have to present evidence, they'd have to it'd basically be a trial. But I don't believe that was the case. At least what the little birdies tell me, it wasn't the case. Ground 3 is no bond set for a Class B misdemeanor. There is a bond set. I don't know if you notice it. It's been set forever, $5,000 bond. This hasn't changed. I know James Freeman thinks this has changed. This hasn't changed in forever. So I don't know exactly what James Freeman is smoking on that. So he says no bond set for a Class B misdemeanor. But then he says bond was posted and paid. Wait, what? With no conditions. There are always conditions on a bond. Just because you don't understand them when you're signing them doesn't mean there aren't conditions on the bond. There are always conditions on a bond. I've never seen a bond with no conditions. I've always seen conditions. You don't say there's no conditions. And they refuse to let Bao have a lawyer present. I don't know if Bao had a lawyer at the time. I don't know if Bao had refused a lawyer. This is weird to me. I don't know that you have a right to a lawyer at that time. I don't know. Maybe under Texas law you do. Ground 4 is unreasonable bond conditions. You can't have no bond and unreasonable bond conditions at the same time. But then they say, he was a good boy, didn't do nothing, etc. And he says that he didn't present all the appeals because the judge refused to answer questions and clarifications, and walked off the stand mid-hearing. It's not mid-hearing. The hearing is over when the judge leaves. And you should have prepared them in a written motion, not try to bring them up, just in the middle of court. Oh, hey, by the way, Judge, I'd like to sua sponte, raise a motion. Say exactly what you want the court to do. He wants the court to recuse the current judge, John Weeks, release Bao on reasonable conditions, and dismiss all charges. I'm sure he does want the court to dismiss all charges. I don't think a federal court would be able to dismiss all state charges. I don't think so. But, it never hurts to ask, right? And so he declares this under penalty of perjury. Congratulations. So this is a notice of right to jury trial that he filed today in Tarrant County. So he filed this with the federal paperwork. I don't know why. Because he filed this on the 10th. At the same time, he filed the federal one on the 10th too, at 12/21. So he filed this at 11:50. So half hour prior, he was filing this at the Tarrant County Court and attached it to his federal. I don't know. So right to jury trial and right to be sentenced by the jury. I don't know why he lists all these things like 42 U.S.C. 1983 and 18 U.S.C. 241 and 242. Fred v. California. Fred v. California is just you have a right to represent yourself. So I don't know why he lists all that stuff. Yeah, the Sixth Amendment says that you have the right to a jury. Texas Constitution Article 1, Section 2. This is irrelevant. It states that it's a Republican government and etc. All political power is inherent to the people. Section 10, rights to the accused in criminal prosecutions. You have the right to a speedy trial and impartial jury, and then the right to a trial by jury. You have the right to a trial by jury remains inviolate. This is all Texas stuff. Then he goes on to try to make the claim that judges can't be judges because being a judge is or judging someone is an act of political power. He fails to take into account the sections of the Texas Constitution that establish the judiciary and how judges make judicial rulings, the Texas Supreme Court, all that fun stuff. He just ignores all that and tries to hand wave it away with, well, it's all judging is an act of political power. Ta-da! You can't judge me. And no, they can, they will. What he's trying to say is that he wants a jury to try both fact and law in his trial. And here we go. He has the right of a jury to decide each and every element of fact and law. No, the jury determines the facts. The judge determines the law. And him playing silly word games won't change that. And then we have an interrogatory upon Darla Peavy. In California, you wouldn't be able to subpoena or depose or do an interrogatory on a victim. It's called Marsy's Law, or the Victim's Rights. The Victim's Rights Bill or something like that. But Marsy's Law, essentially. You can find it by Marsy's Law. Texas, apparently, you can do depositions and subpoenas and interrogatories. I don't know if you could do an interrogatory on a victim. I think interrogatories, from my understanding of the way Texas law works, is that you could do interrogatories in a criminal context if you could do it in a civil context, and you could do an interrogatory in a civil context between parties. So, like, the defendant could serve an interrogatory on, like, the prosecutor to ask, like, what like I don't know, what grounds of, or what laws are you going to rely on, what theories of law, etc., like that. I don't know. I don't know exactly how you'd use it, because you just don't do that in California. So this is a lot weird to me, but I don't think you could serve it on I think what he meant to do was he meant to do a subpoena. I think he meant to subpoena Darla Peavy. Because 24 is subpoenas. He's trying to subpoena. It's all about subpoenas. So, and then interrogatories to parties. So, yeah. So this is the Texas Code of Civil Procedure. Interrogatory may inquire whether a party makes specific legal or factual contention, may ask the responding party to state the legal theories and describe in general the factual basis for the party's claims or defenses, but interrogatories may not be used to require the responding party to marshal all of its available proof or proof the party intends to offer at trial. So this is interrogatories to parties, and I did not see any interrogatories upon others. Now, I could be wrong, because I've been wrong before, but it appears to be that just between parties. So, yeah. But 24.01 is issuance of subpoenas. I think he meant to do subpoenas. He meant to subpoena Darla Peavy. But judicial notice is given of the following authorities in this matter. See, memorandum of law doesn't work this way. Memorandum of law, your typical memorandum of law would you'd state the facts, and you would state you'd say, like, how would you do it? It's hard for me to come up with one on the spot. You state the facts, you'd state the law, and then you'd apply the facts to the law. So, this person had, this money in her pocket. That person stole that money from her pocket. That would be your facts. And then the law would be like Texas Penal Code section whatever says theft of an item from someone's pocket is a misdemeanor, and it defines these things this way. And then you'd apply the law to the facts, and you say, well, the person did this and then they did that, and that comports with these elements of the crime, and therefore blah blah blah, or something like that. So you have the facts, you have the law, and then you apply the facts to the law. This is just shotgunning out random bull crap. Like, what does the Second Amendment have to do with an interrogatory upon Darla Peavy? Really? What does 42 U.S.C. 1983 have to do with an interrogatory on Darla Peavy? What is 18 U.S.C.? So the 18 U.S.C. these are criminal codes. What do they have to do with an interrogatory on Darla Peavy? It's silly. This interrogatory shall operate as a subpoena. Interesting. This must be a Texas thing, or it's just done wrong. One of the two. It's either a Texas thing or done wrong. Let's find. There is no interrogatory. Okay. Well, maybe there's some weird thing, but from my understanding of the Texas Code of Criminal Procedure, the only time you can use an interrogatory is when it could be used in a civil matter. So there you go. So he wants to ask Laura Peavy to face a jury or record, either at trial in this matter, whether being directed, blah, blah, blah. He wants to ask, are you a bitch? Are you a cunt? Have you ever been a bitch? Have you ever been a cunt? Seriously. Have you ever called any other person a bitch? Have you ever called any other person a cunt? State for the record the name of each and every person you claim called you. See, this is stupid. This is stupid. Yeah, I don't think I cannot imagine her attorney not objecting to this. Just have it struck. This is abusive. This is insulting. This is harassment. This right here is harassment. It is not on her to state for this. Remember that under this may not be used to require the responding party to marshal all of its available proof or the proof the party intends to offer at trial. So he's being silly. Etc. Okay. And then this is a notice of intervening state and local law. Again, we have just the formulaic pooping out the Second Amendment in 42 U.S.C. 1983. The facts, the law stated supra exist and supersede any claims of criminal conduct by opposing party. Okay. The law stated supra protect defendants' rights to liberty, privacy, and property. His right to be let alone and to be free from crime being committed against him, and his rights to due process and to be free from malicious prosecution. Yes. Violation of these rights by state officers acting under color of official right are civil torts and crimes under federal law. Yeah. But you haven't shown. Notice, this court has given judicial notice that the aforementioned United States and Texas state law applies to all persons, parties, and proceedings of this matter at all time, including but not limited. Yes, they know all this stuff. It applies. Yes, it always applies. Then any such violation of law stated by any person. Yeah, we get it. That's stupid. Why would you waste anybody's time with that? This document is produced and made available free of charge by the American Justice Corporation. Oh, here we go. Ah, it's kopcam. It's kopcam. Piero Begonia's kopcam. Firecop.com. Whoop, I didn't mean to do that. Firecop.com. Kids these days, huh? Kids these days. Yeah, so we're going to see how effective kopcam is. It's not looking very good so far. And then what do we have here? Oh, this is the second half. Oh, poo. 2 halves. All right. So this is a motion for summary dismissal with prejudice. Oh, this is going to be good. All right. So again, this was filed in the Tarrant County of Texas Criminal Court, and it was also apparently filed in the federal court. I don't know why, but it was. All right, so this is a motion for summary dismissal with prejudice and a notice of hearing. Judicial notice is hereby given to the following authorities in this matter. Again, it's the just vomit. Defendant has been accused of a crime for conduct alleged to have been committed by others. No, he's accused of being a part of it, of calling for it, of advocating for it. The conduct alleged as actus rei is entirely lawful activity. No, it's not. The commission of which, no, it's not. No, it's not. Constitutional protected activity is both an absolute immunity and an affirmative defense. Would it be an absolute immunity? Well, I guess, yeah, if it is constitutionally protected. But you have to show it's constitutionally protected. And the way to actually show it's constitutionally protected, instead of vomiting out the Second Amendment in 42 U.S.C. 1983, the way you actually show it is you go to the law library and you look up Texas Penal Code section 42.07 and you read all the cases that have been tied, that show various aspects of it. So there'll be a section in the law library. If you pull it up on like LexisNexis or something, there'll be a section on it that says, you know, constitutionality, and you'll be able to look it up and you'll be able to see what courts have held as to the constitutionality of it. The kopcam has no idea what a memorandum of law is. A memorandum of law isn't just listing the various laws. I mean, this is useless. The judge is aware of every single one of these. The judge is aware of them. It makes no sense to just say, ugh, the Second Amendment. Because the judge is going to be like, what about the Second Amendment protects Bow in this? What about the Second Amendment means I should grant dismissal? And you'd be like, well, he has the right to bear arms. What does a right to bear arms have to do with Bow's incarceration? Was Bow incarcerated for carrying a firearm? No, he wasn't. But okay, well then shut up. You know what I mean? This is just wasting everybody's time. And just saying that it's a protected act doesn't mean anything. You have to prove it. This motion incorporates and restates the defendant's separate motion to strike as grounds for granting this motion. Oh, so because the defendant has had a motion to strike somewhere, then this motion should be granted based on his other motion to strike, whatever. So number 2 is failure to state a prima facie case against the defendant. The relevant portion of the arrest warrant affidavit states, custody when gave the verbal instruction to approximate 1,000 viewers of the YouTube live stream to start call up here when indicated he did not know the number but that the viewers could Google it. And viewers then started posting the contact numbers for the Crowley Police Department, Crowley City Court, and Judge Peavy's personal office, as she is a practicing attorney. Within minutes of when giving the order for the viewers to start calling, the law office of Darla Peavy received numerous phone calls. The exact number of calls can't be identified as the office does not have, etc. That is a prima facie case that he incited people to, or he asked people, he aided, he conspired with people, he got people to commit a crime at his command. The person who says, go rob that bank for me, is just as culpable as the person who actually goes and robs the bank for that person. A person commits an offense if with intent to harass, annoy, alarm, abuse, torment, or embarrass another, the person causes the phone of another to ring repeatedly or makes repeated telephone communications anonymously or in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. Calling someone a cunt or a bitch is going to offend someone. Having your minions call that person's number repeatedly is an offense. Having them make repeated telephone communications anonymously. How many of those people said their names? Huh? Is an offense. Or in a manner likely to cause, or in a manner likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. Calling someone a bitch and a cunt is going to harass, annoy, alarm, embarrass, torment, embarrass, or offend them. So there you go. According to the charging document, defendant instructed some imaginary group. It's not an imaginary group. They identified them as the 1,000 or so, approximately 1,000 viewers of the YouTube live stream. That's not an imaginary group. That is an actual group of persons to call the location he was being arrested. The facts alleged indicate defendant was not located anywhere near Darla Peavy. The statute doesn't say that he has to be near her. So that's silly. That's not an element. Nor place of business at the time he was arrested. Again, not an element. Irrelevant. The charging document fails to make any factual or evidentiary claim whatsoever that any live stream or YouTube live stream, whatever that may be, was taking place anywhere. It says it was. He gave the verbal instruction to the approximate 1,000 viewers of the YouTube live stream. So apparently up in here somewhere, they said that he had a live stream. That's making a claim. The charging document fails to make any factual or evidentiary claim whatsoever that any viewer of anything anywhere did post anything or call anybody. It says they did. Viewers then started posting the contact numbers. Within minutes, telling viewers to start calling, the office of Darla PV received anonymous phone calls, or numerous phone calls. So yeah, I mean, it makes the claim. The charging document clearly states the instruction, not the order, the defendant gave was for others to call him, not PV. No, he said to call up here. It didn't say to call him. Call up here. So that would be a question of fact that maybe you could bring up. Was he actually instructing his viewers to call Darla Peavy? And you can say, well, I wasn't. He can make the claim that he wasn't. He was intending them to call someplace else. But he didn't exclude it. And there's also indications where he pinned certain judges' addresses and things. He says, all persons are free to call Darla Peavy a bitch. Not if they repeatedly call or make repeated telephone communications anonymously or in a manner reasonably likely to harass. So maybe you don't always have the right to. According to 42.07 of the Texas Penal Code, you don't. The term bitch is an appropriate name for a woman, especially a lewd woman. It has been thought to imply want of chastity. It has not been thought to imply want of chastity, nor to mean prostitute. It is generally held not to be libelous per se to call a woman bitch. Well, no one was making the claim that it was libelous. They're making the claim that it was in violation of 42.07. And then he cites various other states' laws. What would have been helpful in this would have been if he said it's not harassment to call Darla Peavy a bitch, and then he cited a Texas state law that held that it wasn't harassment under 42.07 to phone a woman up repeatedly and call her a bitch. That would have been helpful. All persons are free to call Darla Peavy a cunt. The charging document does not prohibit any person from calling Darla Peavy a cunt. Nothing in the, well, again, 42.07, if you're calling her up repeatedly to call her a cunt, that's going to harass her or annoy her, etc. The arrest warrant affidavit fails to allege any person calling her names consists of any crime. Somewhere in the charging document, it would say that it is in violation of the harassment statute. The charging document would state that. I don't have the full charging document, so I don't know. Did he attach it as an exhibit, or did he just attach the portions that he wanted to talk about? He did not attach the full thing as an exhibit. That is not a winning move. So normally, at least in California, at least in all the things I've seen, you attach an exhibit to your motion. You'll have like a piece of paper that just says like Exhibit A on it. And in this, it says, see Exhibit A, line, whatever, of the charging document. Exhibit A, page 3, line 14, or whatever. You don't just say nothing in it, because you haven't provided the full thing, so that the court can't make the determination without the full thing. And yes, it does. It says that it was harassment. So there you go. And it does. It alleges that it was harassment. 42.07. Charging document fails to state with specificity each and every element of the offense charged, and with specificity which sections of 42.07 the defendant is charged with violating. Opposing party's claim appears to be a shotgun pleading attempting to charge the entirety of Texas Penal Code 42.07A against the defendant. I don't believe so. I think it's A4. Or maybe they have multiple ones, because there probably were people who were calling and intentionally failing to hang up or disengage the connection. I mean, there might have been people doing all of these things. We don't know. Because if 1,000 people were on the live stream, and even if 100 of them called, I mean, they might have had all of these things. Facts alleged clearly indicate that no contact whatsoever was made by a defendant with complaint, and Darla Peavy doesn't have to. He directed her, or he directed his viewers to call. That's what the document is alleging. If he directs them to commit a crime for him, then it's as if he committed the crime. He is an accomplice. He is just as liable as everybody else is. It applies to direct personal contact. 42A1, direct personal contact. Let's look at direct personal contact. No, initiates communication. In the course of the communication, makes a comment. That could be over the phone or not. It just says initiates a communication. It could be a text, I guess. Maybe, maybe not. I mean, some court somewhere's probably ruled on it. Uh, 42.07A4 means that a person caused a telephone to ring repeatedly by some automated mechanism. Does it say automated mechanism? No, it doesn't say by automated mechanism. You're just adding stuff now. Or the individual called the person or called the telephone time multiple times. Not that other people responded to any request to call a particular person. It doesn't say that. It says causes the telephone of another to ring repeatedly. That's enough. Or make repeated telephone communications anonymously, or in a manner reasonably likely to harass an oil alarm. So, yeah, it doesn't mean what you think it means. And unless you can actually cite Texas case law that says it means what you think it means, it doesn't mean what you think it means. Facts alleged indicate the electronic communications were all supposedly telephone calls, and all those electronic communications were not made by defendant. Yeah, they're not alleging the defendant made those calls. They're alleging he had other people make those calls for him. The charging document fails to make any kind of prima facie showing of criminal intent as required by 42.07, and as such is void on its face. No. With the intent to harass an oil alarm, abuse, torment, or embarrass another, and that's what they are alleging his intent was. Then we move on to B. I don't know why we're going on to B. I thought it was a shotgun pleading for A, but now he's on B. Okay. Obscene means. Okay. Containing a patently offensive description of a solicitation, yeah, etc. With regards to A1, while any sexual act with Darla PV might be obscene in se, as might be any description thereof, the arrest warrant affidavit clearly indicates that no solicitation thereto was made by defendant, but it might have been made by someone calling on defendant's behalf. Nor was any description thereof given by defendant. Well, we don't know because we don't have the whole pleading or the whole complaint. The facts alleged clearly indicate the following. One, no party solicited nor described sexual intercourse with Darla PV. It doesn't say that. It does not. It doesn't clearly indicate that. No party described Darla PV. Okay. No describe. Okay. No party. Okay. No party. Nope. Nope. The charge document further states when Darla Peavy returned to her office, she found she'd received numerous calls to her phone line using terms identified as bitch and cunt. She found these terms offensive and profane while being used in an abusive manner. So those are the elements. Profane and abusive. Offensive and profane while being used in an abusive manner. Abusive manner. Abusive manner. Offensive. I don't know where they're getting profane, but all right. But there you go. And she completed a statement, something attached to the incident. nothing in it states that any finding by Darla PV constitutes gravamen of offense. Yeah, it does, actually. Reasonably likely, where is it? Reasonably likely to harass, annoy, alarm, or offend another. An offense with intent to harass, annoy, alarm, abuse, torment, or embarrass another. So you're right. It's not what she finds them to be, but she's making the complaint, and so what you would then try to prove in court was that a reasonable person wouldn't find being called a bitch or a cunt offensive. And good luck. Good luck. All right. So it's what a reasonable person. So you're missing the point. The charging document reads that a person must commit a combination of all of TP 42.07 subsections together or alternately a violation of singular subsection A7. I thought it was A4, but whatever. Two, 3, 5, or 6. 2, 3, 5, or 6. Threatens. Well, we don't know. False report. That one probably hasn't happened. I'll bet you 5 happened. Six may have happened, but probably not. It'd probably be hard to get Bao on it. I don't think Bao would have any way of knowing. I don't think he was telling someone to permit their phone to be used by another person, etc. Unconstitutionality of the charging statute. It's unconstitutional on its face or as applied in the instant case because the statute defendant charged with violating fails to either state or accomplish any compelling governmental objective. I don't know. A compelling governmental objective, that sounds like a First Amendment test. But I don't think so. What he should have done is he should have gone to the law library and find any particular instances where 42.07 was found to be unconstitutional as applied, and then figure out if your fact pattern matches that fact pattern. Or you could just make the claim and hope the judge believes you. Any presumptive compelling governmental objective for the charging statute in this manner can be achieved by less violative means by those applied in the instant case. So this does appear that he's trying to do a First Amendment analysis of it. This would be the strict scrutiny test. Compelling has to serve a compelling government objective, compelling government interest. It has to be the narrowly tailored and the least restrictive means. Less violative means least restrictive. Anyway, so it looks like he's trying to do a First Amendment analysis on it to see if this statute violates the First Amendment. But I believe that there is a compelling government interest. It's to protect people from having their phone ringing all day and all night. And I don't know what less restrictive way you can get to do that than to make it a crime to make someone's phone ring all day and all night. Now, if you could figure out a way in which this is overly broad, or there is a less restrictive way of doing it, then good luck to you. Enforcing the charging statute as it has been in this matter has a chilling effect on all persons engaged in constitutionally protected activity as described in the arrest warrant affidavit. I don't think so, because all you have to do is not have the intent to annoy or harass or whatever. Including this beyond the lawful jurisdiction of the state of Texas. I don't think so. Because of the prosecution of the defendant in this matter, the chilling effect is being and will continue to be perpetrated across state lines. I don't think so. I mean, it's a nice try. I like the First Amendment kind of analyses going on, but I don't think so. Because it is, again, they have to prove the intent to harass, annoy, alarm, abuse, torment, or embarrass the other person. And then you have to do things like make their phone ring repeatedly, and then it's gonna have to be some unreasonable amount of time ringing. Hang up as soon as they answer and then make it ring again. Let's see. If it is opposing party's contention, it wouldn't be opposing party. If it is the prosecution's contention that the language of Texas Penal Code 42.07 is such that singularly committing any of the acts prescribed A1 through A7 constitutes a public offense, then the statute is void for vagueness, as it could be just as easily read as requiring a combination of acts. Could it be? It could be, except for the or there. So it's 1, 2, 3, 4, 5, 6, or 7. So you didn't read it very clearly. Lack of jurisdiction. This court is a court of limited jurisdiction. It is not a court of record. I thought county criminal courts were Tarrant County Criminal Court. I thought. Hold on, let me do. Let's see what it's actually called. Court of record. And there we go. Where are we at? It is a court of limited jurisdiction. It's limited to Class A and B misdemeanors. It is a court of record. This court acts as a trier of fact. Only if there is no jury. If you've already demanded a jury trial, so it will act as a trier of law only, finder or determiner of law, but not a finder of fact. Only facts may be tried here and not the law. You don't try the law. The judge always determines what the law is. Constitutionally protected activity is absolutely immune from being charged as a violation of Texas Penal Code. Again, you haven't proved it's constitutionally protected activity. You've made an argument for it, but you haven't proved it. That the alleged criminal conduct engaged in and was constitutionally protected is an affirmative defense. Because such defense necessitates trial on both the facial constitutionality of the charging statute and its constitutionality as applied In the instant case, this forum is improper, and this case must be summarily dismissed for this court's lack of subject matter jurisdiction to hear and decide defendant's affirmative defense. No, the county court can determine whether or not it is constitutional. That is something that county court can do. And if you, once the court makes the determination that it is constitutional, I don't know if you can appeal right then, but you may be able to appeal right then. Because, yeah, I think you'd be able to appeal right then to, you may be able to appeal to a federal court if it's a, no, I don't think so. I think you have to actually appeal up to the, you'd have to appeal up to the district court, the state district court, and then from the state district court, I believe you could appeal to the, it's not the Texas Supreme Court. It would be the Court of Criminal Appeals, I think, in Texas. And then once they did the determination on whether or not it was constitutional, then I believe you could appeal to the Supreme Court. I could be wrong on that. But the important thing is that yes, the county court can determine whether or not the statute is or is not constitutional. And then if you don't like it, you can appeal that at some point in time. Where was I? Yeah. So no, it wouldn't be summarily dismissed. The court is likewise avoided jurisdiction to rule on dispositive motions. No, it's not. So those are wrong. This court has no more right to decline the exercise of jurisdiction which has been given than to usurp that which has not been given. If you're citing Supreme Court cases from 1821, you've probably done something horribly, horribly wrong. De minimis, availability of another remedy. When females behave as Darla Peavy does, or have the character and personality of Darla Peavy. Wow. As such, perfectly ordinary behavior engaged in by all persons cannot be considered to be any kind of public offense. I think the issue is not just calling her the name, because that wouldn't do one, just calling her the name. And you're not threatening her, so it wouldn't be number 2. Wouldn't be number 3. If you don't use a phone, it wouldn't be number 4. Wouldn't be number 5. Wouldn't be number 6. If you don't use a phone or other electronic communication, it wouldn't be number 7. So, yeah. You can call her names on the street all day long, apparently. Unless it's incitement to violence. So, yeah. Okay. I don't know that she would have a civil action against them unless they published it some way. But calling her and telling her that she is those things wouldn't, I don't believe, necessarily give her a cause of action. There's no penalty for the truth. Oh my God, that's terrible. And in slander and libel, yes, truth is definitely a defense. I don't know how this would apply to the harassment one, because if you call them, it doesn't. It just says it has to be. It has to be. Let's see. In a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend. To harass them, all you have to do is it has to may harass them. So you call them up, and you tell them, you're a ginger. You're a ginger. You're a ginger. It might be true. They might be a redhead, but it still might harass them. It still might offend them. It still might embarrass them or torment them. So I don't think truth is necessarily a defense to 42.07. In short, Darla PV became annoyed because people do not like her. No, she was annoyed because people were causing her phone to ring repeatedly or making repeated telephone communications anonymously or in a manner likely to harass her or annoy her. No one is required to like Darla PV. That is true, but that is, if no one liked her, that wouldn't give her, or that wouldn't give the state the right to bring these charges. It's the calling and telling her that over and over again. Expressing dislike does not, unless you're doing it in violation of 42.07. Notice of hearing. Hereby notifies opposing party this motion dismissed shall be heard on the date of trial or at the next pretrial hearing on this matter after opposing party has received proper service of this motion. I guess if you're in jail, you can't serve your own stuff, so maybe that's the problem. Again, okay, so this is a memorandum of law, again, for Tarrant County Court. Pro se pleadings are held to a less stringent standard, and then the shotgun effect of just terrible things. Trial on the merits. A court should proceed with the understanding is preferable to decide cases on their merits rather than on procedural grounds. Oh, it's an Ohio case. Another Ohio case. Why are you citing Ohio cases, kopcam? Unconstitutionality of state statutes. Marbury v. Madison. Oh, Jesus Christ. That was terrible. Notice of appearance pro se. Do you have to give notice of appearance pro se? Again, the shotgun of the Second Amendment. He's pro se. Okay. Okay. Was anybody stopping him from being pro se? Okay. Court has given notice of defendant. Okay. By the way, this doesn't mean that you can have a non-attorney at your table. Motion to strike irrelevant, impertinent, and scandalous matter. Again, we have the Second Amendment and 1983. Thanks. Okay. He wants to strike all of page 3, a lot of page 2, and 3 paragraphs of page 1. Congratulations. I have never seen anyone strike sections of an arrest warrant. That's new. That's new. Anyway, so that was your trip through La La Land. Kopcam is a horrible. He's not an attorney, and he's horrible at what he does. I made a video on him once. I think I called it like the humble merchant or something like that. He's not good at. He's not good at this stuff. He's not good at this stuff. Again, I like a complaint by a class of persons, and he's throwing in 18 USC in a 1983 lawsuit. He's not smart. He's not smart. Anyway, thanks for watching. Thank you to the Ginger Snap for this lovely video pointing out how silly you are. Thank you, everybody, for going through these federal documents with me. Oh, lovely, lovely. And have a great night.